Let's go to my friend Andy McCarthy. You know my friend. He's a guest on the show before, and of course he's been all over Fox discussing this case too. And this and contributing editor at National Review, and also former Chief Assistant U.S. Attorney. Andy, always good to talk with you. Appreciate your time today. The verdict didn't really surprise you, did it?
No, Dana. Thanks for having me. It didn't surprise me. It's not the verdict I would have rendered, and I say that more confidently than I usually would because ordinarily I just follow the trials since I stopped doing my own. I follow the trials like everyone else does. I read the press accounts, but this time I actually strapped in and watched the trial from beginning to end. I didn't think the prosecutors made out their burden of proof on intent in the murder counts. I could see that reasonable minds would differ on that. I thought the manslaughter count was pretty close to a slam dunk. So I'm not surprised that he got convicted on one. And when it was obvious that it was going to be quick, it was obvious to me it was either going to be all one way or the other, and it wouldn't have been rational to acquit on all three counts quickly. So I think the only verdict, once we heard they were in, the only verdict we were going to get was guilty across the board. But there's a big difference, and this goes to the point you started to make. There's a big difference between saying we could be confident that there was enough evidence there to convict, and the separate question of whether this defendant got due process. And it's funny to hear AOC say, well, it's often funny to hear AOC speak, but on this instance, I think she may be right, but not for the reason she thinks, that this is not a situation where you can walk away saying the system worked.
Yeah. Well, and that's the big question. We're talking to my friend Andy McCarthy. And that's kind of one of the big questions I wanted to ask you before getting into meeting their standard of proof. I thought that the prosecution, I think they presented a strong case, but I also don't think that the defense muddied the water enough. Went from what I was able to see with the whether or not it was unintentional murder. That's what I'm looking back up my notes here. That was second degree unintentional murder. That was he was found guilty of that because I from what I understand, the way that they were presenting this was, absent Derek Chauvin, was what was in the toxicology report enough to cause George Floyd's death by itself. And ultimately, the jury pretty much determined, no, it wasn't. And that's, I guess, how they were able to come to that decision on that charge, correct?
Yeah. One of my big complaints about this, and I generally think the lawyers did a very good job on both sides, but the way this was reported, which is a parroting of the way the two sides explain the case, really misled people about causation, because the way this was covered, you were led to believe either what the police did in the way of restraint and subdual to Floyd killed Floyd, or alternatively, this array of problems that he had, coronary problems, arterial blockage, hypertension, combined with his drug abuse and the fact that he had enough fentanyl in his system to kill a normal person, that had to be the cause. And in point of fact, what the judge instructs and what the law is in Minnesota is that what the prosecutors have to prove is that what they're saying caused death was a significant causal factor. It doesn't need to be the only one, and there's nothing that says it can't interact with other ones. So I don't think anybody could look at this and say what happened on the street between the cops and Floyd was not a significant cause of death, even if it triggered or interacted or exacerbated these other conditions. So I didn't think this was a causation case. I thought it was more subtle than that. What I thought was Chauvin's position, and I think this should have been clearer, was that a normal person who didn't have this array of medical problems and drug abuse that Floyd had would not have died from what the police did to Floyd. So they restrained him, they subdued him, they violated a lot of their own policies in the way that they did it. but it would have been reasonable for Chauvin to think that what he was doing was not creating a lethal threat, because somebody who was normal and healthy would not have died from this, and that what actually killed him was the combination of the restraint and his other problems. And that really goes more, Dana, to Chauvin's intent than to the causation. And I think they play too much emphasis on a causation argument they couldn't win, and not enough on Chauvin's intent.
That's a great point. That's a very good point. We're talking about this, which is why he is who he is. We're talking to my friend Andy McCarthy, New York Times best-selling author. And Andy, the other big, I think, issue of debate is whether or not the jury was able to remain impartial throughout this entire thing, because during the jury selection process, that's when it came out that the city had settled with the Floyd family in George Floyd's death, which we all thought was, well, that seems a little early, and during the jury selection process. And then obviously you had the media reports, you had Maxine Waters, who went out there and said what she said, and it even brought the judge in that decision, who is, I guess, if we had to say what political ideology he was, I mean, he's not exactly conservative, but he made the statement that, you know, maybe there could be an appeal based on Maxine Waters, her words and involvement, which I don't know if Chauvin could win that, but the jury. I don't necessarily think that do they have to be fully sequestered? I mean, there were criticisms of the judge that he didn't move the location, that the jury wasn't fully sequestered. But I go back to Darren Wilson's case in Ferguson, and the grand jury, before they determined not to indict him, they weren't sequestered at all. And there was a lot of media leaks and all kinds of stuff. So do you think that a jury can still, Andy, remain impartial, or is that really incumbent on whether or not they are sequestered?
It's not wholly incumbent on whether they're sequestered, and every case is different. Every situation is different. I've tried to compare it to this, Dana. When I was trying the blind shake in 1995, in the middle of our trial, the Oklahoma City courthouse was bombed. While we were on trial with jihadists who had bombed the World Trade Center. And the first reporting suggested that the blind shake had ordered the bombing in Oklahoma City. We didn't have any evidence that suggested they had anything to do with it, but people kind of ran with those rumors. So the defense lawyers came in and they wanted the jury sequestered to isolate them from the media coverage. And our judge said, we're not going to do that. We're going to instruct the jury that there's no connection, because we were representing as the government that we don't know what happened, but we don't have any evidence that there was a connection, and it's not part of this case. And then he said, we'll see what will happen. And the point is, we still had 6 months to go in our trial. It would have been very difficult to ask the jury to strap in away from their homes and away from their lives for 6 months. Yeah. Now, in Minnesota, the state law is you're sequestered during deliberations. And even in our trial, federally, our jury was sequestered in deliberations, even though that's not routine in all federal trials. But in state trials, they're usually sequestered in big felony cases anyway. So my problem with what the judge did here is that when the Brooklyn Center incident happened, they were on the last day of evidence in their trial, in which case they could have, if he had sequestered the jury then, they could have gone right into summations, charged the jury, and get them working and deliberating right there and then. So it would have been a couple of days of sequestration, which were going to happen anyway, right? Instead, what he did, and this is important for two reasons. One has to do with what we're talking about, and one is also how we should gauge what the jury did in coming back so quickly. He not only didn't sequester them, he gave everybody Friday off. So he sent them home for a long weekend under circumstances where everybody knew they were going to be marinating in what was going on in Minneapolis with the rioting and the intensive publicity and everything else. So that's one thing. And that's on a record where all these other things had happened, which call into question whether the guy could get a fair trial in the first place. But here's the other thing, Dana, and I don't think there's enough attention been paid to this. He gave the lawyers Friday off because the case was so complex and the record was so replete with this technical medical testimony and this use of force expert testimony. They had these manuals of police practices and all this other stuff. The record was too big and complex. He thought the lawyers should get another day to prepare. Okay, that's reasonable. Flash forward to Monday, Tuesday. The jury is out for less than a day. They do not send a single note out to the judge asking, can we have this testimony reread? What's the refined legal position about like intent here or use of force there? No questions from the jury. No questions about the evidence. No request for readbacks of testimony. Nothing. And all of a sudden we hear, in a case that the lawyers needed a day off to prepare for their summations, the jury is back in less than a day with verdicts on all three counts. Now, look, I'm not saying that this case is getting overturned on appeal, because that's very uphill to get a court of appeals to overturn a case on the ground that the guy didn't get enough due process under circumstances where the evidence is pretty convincing. But if he was ever going to make that motion work, the thing that had to happen is the jury had to look like it didn't seriously consider the case. And this record lends itself to that interpretation.
Wow. That's a really good point as well. Talking to our friend Andy McCarthy, New York Times best-selling author and former assistant U.S. attorney. Because that was quick. Normally, when it's that fast, that not always, but it kind of does suggest a guilty verdict. But that's a good point, because they only had some of their notes to go on and really their memory. Right. They didn't really have anything else to look at, and yet the lawyers needed an entire day for summation.
To prepare for summation.
That's crazy.
And then they spent more time summing up than the jury did deciding the case.
That's unbelievable. That's unbelievable. I get so worried about encouraging any kind of erosion of trust in our due process and our republic, because it's so fundamental. And I know that there are ideologies in this nation that would love nothing more for something like that to happen. But that is a really good point, and it does kind of call into question: was this? Was the jury kind of responding to everything around them? And this, as you note, this case was so unbelievably technical. I tried watching some of the medical stuff, and I'm not going to lie, my eyes were glazing over because it was getting so ridiculously technical, which it needed to. But for laymen like me that have no idea about any of the stuff that they were talking about, it was really difficult to follow. And I know that the jurors weren't made up of medical professionals that we know of. So that was tough for them as well. One last quick thought from you, Andy. You had Merrick Garland go out there kind of signaling a return to the Obama, Eric Holder days of the DOJ. What did you take away from his remarks on the review of Minneapolis policing? And do you think that this is going to maybe lead towards a step of D.C. wanting to perhaps nationalize standards and practices for police around the country?
Yeah, Dana, I have a column that'll be out in National Review this afternoon about this, but this is Obama all over again. I wrote a column about 7 years ago explaining what the game is here. So what happens is the Justice Department knows that they're not going to be able to make a civil rights prosecution against the individual police officers against most of these cases. Mm-hmm. So what they do is they stir up the pot just like the other agitators do, and then they slipstream in behind these controversial police-involved instances, and they say, we're opening an investigation. And then almost immediately after it's clear they're not going to bring an actual prosecution, they say, however, we've seen enough disturbing things here that we're going to bring what's known as a pattern or practice investigation against the entire police department, not the individual cops who were involved in these instances, but the entire police department. And they use a 1994 law that was enacted with Clinton as president and Biden pushing it through, by the way, in the Senate. And this allows the attorney general to file a civil suit anytime the Justice Department suspects that there's a pattern of or practice of discrimination being practiced by the police department or the municipality. And the thing is, the Justice Department has a $28 billion budget. No municipality can go toe-to-toe with them. So what they end up doing is settling and signing a consent decree, usually with a federal monitor, that agrees basically to Obama-certified progressive policing practices. So there's nothing new under the sun.
Yeah, well, it definitely not. Goodness, and that is the whole game. Andy McCarthy, we appreciate your time. Always wish I had more time with you whenever we have you, but we are grateful that you're so generous with yours. Thank you so much, my friend. Look forward to reading your piece, and I know we'll talk again soon.